Hi, welcome back to Space Thoughts. Yes, it's been about over a month since I've done a video, but an event happened yesterday that I thought was important enough to sit down and take the time and make a video. The vice president got up and gave a speech and basically talking about non-governmental commercial space or private space yesterday. And essentially the underlying theme of her speech was that the executive branch is creating this whole new framework for commercial space activities or regulatory framework for commercials or non-governmental space activities to purportedly facilitate these activities in outer space. In other words, to keep U.S. leadership in the non-governmental space sector. So it was really interesting, inspiring. A lot of news people caught up with it and thought, "Oh, this is a great thing. We're finally moving forward with commercial space." But I was a little bit concerned for a few reasons. And again, this is just based on a speech, and without having a lot of details. There's going to be more details coming up on September 9th with the National Space Council meeting. But fundamentally, first concern kind of really relates to the approach. Now, there are two underlying philosophies about how to regulate non-governmental space. On the one side, you have the viewpoint that I ascribe to is that you basically start doing these commercial space activities. You authorize them under the Article 6 authorization, whether it's the FAA, the FCC, what have you, and you allow these non-governmentals to perform these activities and get some experience and learn the ins and outs of the space activity. Government then steps in its role under what we call continuing supervision, which is in Article 6 of the Outer Space Treaty, and basically says, okay, based on your experience, we think we need to regulate here, just tighten up here. Or the government says, you know what, you're all doing, these non-governmentals are doing a good job. We really don't need to interfere, so we're not going to regulate it. That's one side of the philosophical argument. And I hesitate to really call it a philosophical argument because the approaches have significant consequences, as I'll demonstrate further. The other side of the coin is the side that basically says, you know what, we got to lay down, we got to preemptively lay down all these regulations, create a regulatory framework, and we have to, that way when non-government goes out, they'll know exactly what their boundaries are and and they can only go so far or do things in a certain way. Well, that sounds good, and in a really prescriptive environment, yeah, that works because basically you're saying, okay, I'm the government, I'm responsible, I'm telling you what you can do and how you can do it. Even though we don't really know we're not really sure how this is really going to work. So really, it's basically like a mouse in a maze. Basically there's a piece of cheese. In order to get to the piece of cheese, the mouse has to go through all these different labyrinths of the maze in order to get to the cheese. That these artificially created labyrinth and obstacles have to get through it. And that's kind of what this approach does, as opposed to the other one where it's basically wide open and let the mouse meander its way through and find the cheese on its own. So again, on one side, the side that I subscribe to and that I prefer or think is the best way is this idea: let non-governmentals go out, explore, perform these activities, authorize them. They're going to make mistakes, but let them learn from the mistakes and regulate based on their experience. And then a lot of times, industry will come back and say, "Look, we need some help. Based on our experience, we need some help here." And we're finding that out with this rendezvous and proximity operations, which have been going on for a while now. In particular, with Northrop Grumman's work with their and Intelsat clients as well. But on the other side, we have the more it's basically more a lawyer bureaucrat approach saying we know better. We're going to tell you how you should do it, even though we don't have any experience doing it, and you just got to follow our guidelines and do the best you can. And that seems to be the approach that the administration is taking with this idea of a regulatory framework. And again, I don't like it because I think it's going to stifle. It really is the antithesis of learning through experience, as opposed to said, well, we're going to predetermine how your experience is going to be, and such. So again, I think that's, in my opinion, that's the approach that the administration is going to take with this regulatory framework. The second concern with this is, can the administration really do this? And it comes down to a matter of this whole idea of authorization. The last time the U.S. updated its commercial space laws was in 2015 with a massive bill that covered a lot of things and actually granted the authorization for Planet Space Resource Act activity as well. That was signed into law in November. And basically, and had a bunch of other things into it. But the big problem here is, and one thing that the regulatory agencies like the FAA and such have, is that they have no specific authorization for these, quote, non-traditional, non-governmental activities out there, like rendezvous and proximity operation is a good example. The FAA had to do, had to play a legal and administrative game of Twister in order to really get these missions authorized. And it's really not, and it's really a workaround as opposed to a blanket authorization from Congress that can do it. So understand that Congress is the author, is basically grants the federal agencies the authority to authorize these types of activities, and from there they regulate it. However, in this case, from what the administration appears to be doing, they want to go in their carte blanche, introduce a new regulatory framework for non-governmental activities, but yet we really don't have, Congress hasn't really spoken. Congress hasn't granted these agencies the authorization to do it, and that's going to be a problem. And I think it's going to put the agencies in a conundrum, and it's going to cause some issues. I think a really big one is space debris. Obviously, this whole idea of sustainability, I have my opinions about it. I'm not going to go into it here. But this whole idea of space sustainability is really about orbital space debris, and a lot of and some of these regulatory frameworks that the administration may be creating actually deals with regulations on orbital space debris. However, the question is, does the FAA and other FAA have any really authority over space debris? Now, I did a little bit of, I perused Chapter 509, which is basically the commercial related part of Title 51, and I found one mention of space debris, and that was basically with a mandate to develop technologies for space to basically mitigate space debris. And that was it. No authorization saying you shall impose this on the on licensees that to do this and to follow these regulations about not producing space debris. However, you have the FCC, which has its Article 6 authority through the Communications Act, and basically when during an application for a communication satellite, the licensee has to basically create this plan for a space debris mitigation. In other words, how are you going to dispose of this thing when it's over? In other words, if you have a satellite in geosynchronous orbit, tell us your disposal plan for getting rid of this thing afterwards. And usually that's lifting it to, saving enough fuel to lift it into a graveyard orbit to free up that slot. A big one on the space debris mitigation has been with SpaceX and Starlink. There's been a lot of back and forth with the FCC about their mitigation plan, and really the FCC is basically going along, seeing how it goes as these Starlink satellites get launched. And actually, there were 2 launches this past week of Starlink satellites. So the FCC uses the Communications Act very cleverly, and I might talk about that just a little bit towards the end of this video. But the question is, but when it comes to like the FAA, when the FAA is the primary authority, it really doesn't have the authorization to regulate space debris creation by non-governmentals, because Congress hasn't really stepped in and authorized it. And of course, we get back to this idea of non-traditional activities. There are, any rendezvous and proximity operations, and other types of operations outside of, basic space tourism haven't really been approved by Congress. Congress hasn't given the FCC authority. It also hasn't given, the FAA authority. It also hasn't given the FAA what we call on-orbit authority, which goes into this idea of continuing supervision, where basically the FAA is has authority over launching and reentry, but everything in between is kind of a gray area because Congress hasn't given it any specific authority there. And that's been a big controversy for a long time, and Congress has been kind of reluctant. So my question is, again, with this regulatory framework, what's going to happen when they put this in? If Congress hasn't acted, what's going to happen with this? Well, and I think that's going to be a really big issue, because it basically is what we call a separation of powers issue in the Constitution. Congress and Congress comes out really strong on this, is that basically we are the ones that give federal agencies authority to regulate. In other words, we give we can say you have this authority and we want you to regulate on it. I think a good example is with the NTSB. There's been an issue ongoing for the past several months where the NTSB is trying to step in and assume almost exclusive jurisdiction on the authority over the investigation of accidents involving commercial space launches, whether it's suborbital or orbital. And they are using a very vague. They're using a vague portion of the U.S. code to assume that authority. And there's been some pushback from the House of Representatives. There was some language in the appropriations bill. If you subscribe to my briefing letter, I will be talking about that in this upcoming issue. But the big idea, the big thing is, the NTSB says it has this authority, but it's using a very vague portion of the federal statutes, a certain federal statute, to actually assert that we have regulatory or exclusive jurisdiction over this. So again, it's a very big gray area. So the question is, what if the administration tries to impose this regulatory framework, goes to its agencies that, like the FAA, NOAA, the FCC, we want you to create all these regulations. Well, I think there's going to be a problem. One, because right now there's still a moratorium on the creation of new regulations for commercial spaceflight in particular. And I believe that extends till the end of December 2023. I have to check that out, but I believe it's then. So essentially, there is a congressionally mandated moratorium in effect right now. So any regulations that the White House, that the executive branch tries to impose on to command its executive agencies to perform is going to run into that roadblock. And the question is, do they, the agencies will have to deal with that. Well, we really can't do anything because of this, and they're going to have to try and interpret it. The second one comes into the fact that they don't have the authority to actually regulate. And again, this has been a big thing with the FAA in particular, authorizing these non-traditional activities where they've had to basically playing administrative twister in order to get these rendezvous and proximity operations going. So what's going to happen? Well, interestingly, the Supreme Court actually dealt with this in a case back in just a few months ago, and they came up with a big decision. The opinion is called West Virginia versus EPA, and just the long and short of the case, the EPA has basically been trying to use the Clean Air Act in particular to basically address climate change. And the town of the state of West Virginia plus some other co-defendants from other states basically came up and said, no, this authority isn't expressly granted by Congress in the Clean Air Act or anywhere, and they can't do this. And the Supreme Court actually sided with them, and they basically the gist of West Virginia versus EPA is, look, if you're an administrative agency, Congress gives all the authorization for what you do. You can't make regulations outside of the authority that Congress already gave you. In the case of the Clean Air Act, Congress could not Congress only gave certain respects to certain authority to the EPA to regulate. It didn't give a specific authority to regulate on the issue of climate change using the Clean Air Act. So in that case, and basically that's why the Supreme Court found it. But even though this case was focused on the EPA, this rationale, this jurisprudence, this decision actually flows over to all the other executive agencies, including the FAA, NOAA, and the FCC, which are the three primary authorizing authorities for commercial space activities. And I did a video a while ago on the three rings of authorization and licensing in the U.S. And what I'll do at the end of this video, I'll link it up in the corner so you can go back and watch that. It's really informative, and basically it's a quick overview of how commercial space licensing, how Article 6 is actually administered here in the United States. So again, taking this rationale from the Supreme Court, what if the administration imposes this massive regulatory framework and basically tells the agencies go forth and do this? Well, the agencies have a problem because in a lot of cases, I don't think they're going to have actual legislative authority from Congress to actually come in and actually create it. For example, let's use space debris, because I'm sure this is going to come up in the context of this regulatory framework. If there is a regulation, say commercial space operators shall do this, this, and this in order to mitigate space debris or to ensure that space debris isn't long-lived, there's the FAA. Let's take the FAA, for example. Well, they can't create a regulation out of that because they don't have any specific authority from Congress. Now, will they try and do it? I don't know. That's the question. However, if they do try and do it, that could open up to litigation. And basically, this idea of West Virginia, the rationale in West Virginia versus EPA, that would probably be one of the primary cases cited in federal court, saying, look, the FAA can't do this because Congress has not acted on this. Congress has not authorized them to create these regulations on the mitigation of space debris. Hence, it's void because of separation of powers. And I think this will go through with the other agencies as well, in terms of the fact that right now, what the administration appears to be doing or wants to do is very ambitious, but it's outside the scope of what Congress has already authorized the agency. So it really can't. So they really can't do it, not under the cloak of the Constitution. If they try and do it without the authority of Congress, it's a violation of separation of powers and on its face unconstitutional and could be challenged in federal court quite successfully, in my opinion. I know we all have our different definitions of fun, but just for quote fun for myself, I started thinking up what a complaint would look like in a sense, say a litigant, say a non-governmental actor who would have judicial standing to challenge this and stuff. And I actually been thinking about what this complaint might actually look like in the future if this should actually get into litigation. But the idea is if it does go to litigation, because of that holding in West Virginia v. EPA, they would the non-governmental would likely prevail because of the separation of powers issue. I mean, the West Virginia case is extremely important. I mean, it's probably one of the it's a huge case, it's a huge decision, and it'll have ramifications for probably decades unless it's overturned, and that could happen, and that could happen down the road perhaps. But for right now, that is the law of the land. There's this case called Marbury versus Madison, where the Supreme Court basically said, we say what the law is, and I just love that. And basically, in this case, the Supreme Court has said this is what the law is. Agencies cannot go outside the authorization given by Congress when regulating any activities. So I think this is going to be an issue with the way the administration is approaching it, unless, of course, the administration said, look, this is a policy statement, or Congress, this is what we would like to see as a regulatory framework. We are suggesting this is what we'd like you to see to talk about and act on and basically legislate on. And that's kind of how that it's worked with other administrations. They basically created their ideas of how things should be done or changed for regulatory bodies, sent it to Congress to see if they would get acting on it, and if they did, they sent it to the agencies, and the agencies with the proper authorization can do it. A biggest case is the first Commercial Space Launch Act, which is basically back in 1984. President Reagan signed the National Space Policy that basically said we want non-governmentals performing space activities consistent with international law. And with that policy decision, that policy stance, Congress took over, and and I'm going to emphasize bipartisan because it was truly a bipartisan effort. Congress passed the first commercial space launch bill, which basically started the whole ball rolling and is basically amended and now codified in Title 51. So if the administration's taken that tack, saying, Congress, we have this idea for our regulatory framework, we would like you to act on it. That would be a proper way. But if the administration tries to say, go directly to this agency and say, we want you to implement all these regulations, they're going to have the agencies are going to have a hard time doing it. The lawyers are going to have a lot of headaches. A lot of their lawyers are probably looking at this right now saying, this could probably be a headache. Anyway, this is probably going to be a headache, and they're getting their Tylenol or Advil prepared just to deal with it, because of the simple fact Congress hasn't acted. So the big thing is getting Congress to act. Congress hasn't passed a major bill, hasn't passed major legislation on commercial space law for Title 51 since 2015, and to be honest, we're really getting behind on it. There's a lot of things that need to be addressed that haven't been. For my briefing letter, I cover legislation. There's at least I would say almost 20 pieces of legislation right now sitting in the 117th Congress, and they're really and most of them are just not going anywhere, and they're probably going to die at the end of the year. Again, not trying to get up on a soapbox here, but I'm just saying that the idea is even if Congress at this point, even if the administration at this point made this recommendation or suggestion to Congress, it probably wouldn't get accomplished in the 117th Congress, especially with the midterms coming up in a few months. And again, depending on how the midterms turn out and what the makeup of Congress is and what the political environment is, nothing may get done in the 118th Congress. And well, it's a kind of a wait and see thing. But what I want to emphasize is specifically because of that holding in West Virginia versus EPA, if the administration tries to come in and carte blanche, just plop a bunch of regulations into the CFRs, the Code of Federal Regulations, it's not going to work. It's going to be open. It's going to open up a lot of litigation, and that ruling is just a powerful piece of precedent, powerful piece of law, of interpretation of the law that the Supreme Court made, that is going to that would basically beat this back and say, no, you cannot do that. Congress has to act. And I guess, and again, it's a whole thing about separation of powers. If you're not an American, I know you think your states probably do things differently, but here in the U.S. we have the three separate branches of government, and what the Supreme Court was trying to do is get those, basically saying, no, this is the way it works. Executive branch enforces the law. Congress makes the law. Oh, and they also grant the authority to the executive agencies to make regulations, but it's got to be consistent to it. Just a little aside, I talked about the FCC and the Communications Act. The FCC basically has primary licensing authority. They are the primary authorizing agency for any space station, that's what they call satellites, that are the primary use is to broadcast or use the spectrum, the electromagnetic spectrum, or certain frequencies. Because basically their idea is, well, it involves directly communication. So not only would we get to license the spectrum, but we also get to license the launch itself. And we're going, and we have these debris mitigation standards in Part 25 of the CFRs. I forgot the actual Code of Federal Regulation, but based on a very vague part of the Communications Act, they've assumed all this authority, and even they even consume what we call on-orbit authority, just based on a vague reference in the Communications Act. And honestly, I think that the holding in West Virginia versus EPA might actually open up some a potential litigation there to actually challenge that authority. I'm not saying it's going to happen, but that holding in that case is going to open up a lot of doors and bring into a lot of question a lot of some of the regulatory authority right now of the federal agencies. And interestingly enough, I talked about Viasat's appeal, which is still pending before the appeals court in DC, based on the National Environmental Protection Act. This holding in West Virginia versus EP, I think, is going to have a big effect on how that is decided in the Court of Appeals. And if it goes to the Supreme Court, I think it's going to have an even greater effect in the way it's decided if it goes to the Supreme Court as well. I'm not going to go too far into that because I'm just kind of waiting to see whether when this case is actually going to come out of the out of the Court of Appeals. But anyways, I wanted to talk to you about that. I think what the administration is trying to do, if they're trying to do just a big plop right into the CFRs, I don't think it's going to work, just because Congress hasn't acted. And I'm not going to get too much on a soapbox here and talk about Congress needs to get on the ball, even though they do, because our laws are getting, in my opinion, are getting behind. And I think we're going to find ourselves way behind the curve in the next few years if we don't sit down and start addressing some of the, modifying these laws some more to help move our non-governmental space activity forward. In other words, if we want to become the jurisdiction of choice, we got to keep our laws up to date and keep things moving forward. So I am not going to bore you any further with this. I hope you're safe. I hope you're healthy. The end of summer is near here. If you're in the Southern Hemisphere, you're just about getting out of winter and heading into your spring. So again, stay safe, stay healthy, and I'll talk to you next time.